In this video, we will be dealing with two amendments. Because of small amendments, we will take two sections. One is section 168, which deals with, you all know, deals with the resignation of director. Deals with resignation of director. And second one is 173, which is conducting of board meeting, in which there is an amendment in quorum. We will discuss that as two parts. So first we will discuss about a small amendment, or even though small, it is very important amendment for the education, that is your exam purpose and also the practical professional purpose. Section 168, as you all know, section 168 is a new provision in the Companies Act 2013, which speaks about resignation of director. In the earlier law, that is 1956 Act, there was no express provision with respect to how to resign the position of a director. And there was many case laws where, which was been discussed in the 1956 law, that when a director expresses his willingness to resign from the office, it itself is this, satisfies the compliance of law. Because why? There is no express provision in the 1956 law as to how to resign. In contrast to that, in 2013 Act, when it was introduced, there was a new section 168 which speaks about how to resign. What is the procedure to resign? And most of the students may know. Anyway, I will just go through the few points. One, a director should give a written notice to the board, and the board should take note of that at a board meeting. And after that, the board should take steps to file form number DR12 with the registrar of companies within 30 days of getting the resignation letter. In turn, the director should also file DR11 form with ROC stating the reason as to why he has resigned. Now there is an amendment, there is the amendment in 2017 Act, which speaks about the filing of form DR11, that is the intimation of resignation by a director, including stating the reason why he has resigned to the ROC, which was a mandatory provision in the 2013 Act. Now in 2017 Amendment Act, Companies Amendment Act 2017, there is a small amendment, tricky amendment. The word now is the director. The word is may forward his intimation letter to the ROC. That word shall has been changed to may. That means now filing of form number DR11 or intimation of his resignation, director's resignation to ROC by the director has become optional, may. But in 2013 Act, it was a mandatory provision. Company should file DR12, the director should file DR11. Now, filing of DR11 by the director has become optional by an amendment through amendment in the 2017 Act. This is the only amendment in section 168. I will repeat again, section 168 deals with the resignation of directors. It speaks about the provisions of resignation of directors, including the procedures. But in that procedure, there is a relevant amendment has brought in which speaks about the director, if required, or director can optionally give form number DR11 his intimation along with the reason to the ROC. It was mandatory. Now the amendment has brought that filing of DR11 by the director himself to the ROC as an optional matter. So leave it. That is the amendment. Now coming to 173, which is a very famous section. Section 173 of Companies Act 2013 speaks about conducting of board meeting. Most of the students may be, very happily knowing the provisions. A board meeting should be conducted, 4 board meetings should be conducted in a year with a time gap of 120 days and so on and so long. And it speaks about notice, 7 days written notice to be given to all directors in India. And if you go through the provisions 173, you will see a main provision called quorum. What is the quorum? I think most of the students have known it. What is the quorum? 1/3 or 2, whichever is higher, provided if the number of interested directors is 2/3 or more of 2/3 of the total strength, then for that time or for that agenda, the quorum will be 2, and that 2 should be a non-interested director. We all know that. But the amendment has brought in the quorum is with respect to the presence of directors who attends through video conferencing or audio visual means. So here is an amendment. The amendment is only about this thing, presence of directors through video conferencing or audio conferencing modes. Students may recollect that there are few agenda items in the board meeting which is stated in 173 Red with rules, that In that, and while passing that agenda item or while discussing that agenda item, the directors should not participate through audio or video conference. What are that items? To list out: one, approval of financial statements, board's report; two, approval of prospectus, right? Prospectus and proposals like mergers, amalgamation, right, takeover, substantial acquisition, etc. There are few more items. To the brevity, I am just listing out. These are the items which require a lot of deliberations. So that is why the law says these items should not be passed at a board meeting where directors are attending through audio or video conferencing method. So the intention of law is they should be physically present and they should deliberate the items. Now, what is the amendment which brought in? The amendment which is brought in now here is these restricted items can be passed in the board meeting even though the directors are attending through video or audio conferencing. But the condition brought in is there should be a minimum quorum of directors that should be physically present at the board meeting room. Now I will give an example. For example, there are 10 directors, say, the quorum for 10, for example, I will write here, okay, 10 directors, the total strength, that is the TS. Total strength is the TS. The quorum is, say, for example, quorum is 4. Now, at a board meeting, few directors are willing to attend through audio or video visual means. But the restricted item is being there in the agenda item. In the earlier law, that is 2013 Act, you can't pass that. Because why? Because if the restrictions items are there, directors should not participate through video conferencing. Now, an exemption has brought. In our example, for example, 10 is the total strength, there are 4 is the quorum, that means there are other 6 directors also to make it total strength. So the quorum is 4. If these 4 directors are attending the board meeting in a physical mode, in a physical presence, then the other 6 directors or any of the 6 directors can attend through video conferencing or audio conferencing mode, even though these restricted items are discussed. So that is again a practically liberaling concept, because there are companies where physically there may be the minimum number of directors, the quorum is there, but even though that some directors are willing to attend through audio video visual means, we can't permit because these restricted items are here. Now this amendment has made it easy that if the minimum number of quorum, that is for example 4 or 5 or 6, whatever may be, that number of directors are physically present here, then even though restricted items are taken, even though restricted items are there in the agenda, other directors, the minimum quorum directors should be present physically. The other directors can attend through audio or video visual means. So these are the 2 things which I have included in this video, which is practically very relevant, tricky. In fact, in exam point of view, is very tricky questions, because the students who had not known this amendments will be in trouble. So that is why this lecture is going on. So I'll brief it again. Section 168, resignation, DR 11 has made optional. In 173, quorum, there is a change. In online, attending through online, they are given exemption if provided there are minimum number of directors, the quorum number of directors is attending physical mode. See, there are these 2 amendments in this video.